Technology transactions. This presentation identifies the key components of common technology transactions such as patent sales, licenses, distribution, OEM arrangements, technology transfers, strategic alliances, and intellectual property-backed financings. A patent sale is an outright transfer of all patent rights from the seller to the buyer. Patent sale transactions take place in all technology sectors. Virtually any patent is sellable where a willing buyer is matched with a willing seller. However, patent sales are very popular in fast-moving, high-technology sectors, where successful organizations often switch strategies in response to the dynamics of the market. The transaction process starts with identification of the patents and intellectual assets to be sold. This may be the result of a cataloging activity that maps the claims of existing patents against the current and future requirements of the business. An anonymous listing is then written and posted on the Tynax Patent and Technology Exchange. The listing is syndicated to targeted buyers and brokers or agents representing buyers all over the world. Upon execution of confidentiality agreements, details of the patents and associated assets for sale are provided to buyers. Buyers often have questions related to licenses and other potential encumbrances to clean title. Some buyers have questions related to potential infringement. One of the first questions asked by the buyer is the price. For this reason, the sales process can be more effective when an asking price is circulated with the listing. For larger, more complex transactions, technical questions may be posed. Following this question and answer process, the buyer may make a tentative offer. If there are several interested bidders, a bidding process may take place. Following the negotiation on price and other terms, the preferred offer is then accepted by the seller. The buyer then usually provides a patent purchase agreement to the seller and commences the due diligence process. Due diligence in this type of transaction generally focuses on validity of the patents and ensuring the seller's title is clean. Prior art investigations may be carried out by the buyer. Any licenses, liens, or other encumbrances need to be disclosed and discussed during the due diligence process. After the due diligence process is complete, the closing process involves transfer of payment in exchange for patent rights and recording of the assignment with the Patent Office. Clients in patent sale transactions are often concerned that their patent sale activities are kept confidential and not disclosed to the industry. The identities of the seller can be shielded until the NDA confidentiality agreement is signed by the buyer and the patent numbers are disclosed. Many corporate sellers are highly selective about the type of buyer they're prepared to engage with. They're usually reluctant to sell to enforcement-focused buyers. This is particularly true of corporations that have become the target of patent infringement suits from these buyers in the past. Often the seller will refuse to sell to a direct competitor as well. The role of the intermediary is important here in presenting the divestment assets only to buyer types that are approved by the seller. When the concerns of the seller are known by the intermediary, promotion of the assets can be restricted to the type of buyer that would make a good match and fit within the seller's guidelines. A seller with an existing client base, an established product line that is not being sold as part of the sale transaction, will usually request a license back that enables them to continue servicing their customers without the fear of a future patent infringement suit from the buyer. As for negotiating points, pricing is always a significant factor in these negotiations. However, other issues are sometimes even more important in finding win-win deal structures that meet the demands of each of the parties. The scope of a license back can be the source of much discussion. The seller wants to maximize flexibility in the scope of the license back, while the buyer wants to restrict the scope so that it does not interfere with their patent rights. Where the seller is suspicious that the buyer may be overly zealous in enforcing the patents, The seller may wish to incorporate a covenant into the assignment contract that restricts the buyer from aggressive litigation and threatening licensing activity. This may become a topic of some negotiation. The opposite of an investment, a divestment generally refers to the disposal of a business unit by a corporation. Divestments take place across all technology sectors. However, they're highly prevalent in the high-tech industries where corporations experience rapid changes in business strategy. Although any organization can divest of non-core assets, most of the divestment activity involves high-tech multinational corporations. The transaction process is the same as that of a patent sale. Both buyers and sellers in a divestment involving patent rights are often concerned that their negotiations and activities are confidential and not disclosed to the market. The identities of the seller can be shielded until the NDA confidentiality agreement is signed by the buyer, and the patent numbers are then disclosed. Working through intermediaries, the identity of the buyer can be shielded from the seller up to the point of the closing, although this is unusual and the name of the buyer is normally disclosed at or before execution of the NDA. In extreme cases, anonymity can be maintained throughout the process, and the assets can be acquired by a shell company or agent acting for an undisclosed buyer. Many corporate sellers are highly selective about the types of buyer they're prepared to engage with. These sellers are usually reluctant to sell to enforcement-focused buyers. This is particularly true of corporations that have become the target of patent infringement suits from these buyers in the past. Often the seller will also refuse to sell to a direct competitor. The role of the intermediary is important here in presenting the divestment assets only to buyer types approved by the seller. When the concerns of the seller are known by the intermediary, promotion of the assets can be restricted to the type of buyer that would make a good match and fit within the seller's guidelines. A seller with an existing client base and established product line that is not being sold as part of the divestment transaction will usually request a license back, enabling them to continue servicing their customers without the fear of a future patent infringement suit from the buyer. As with any patent sale, the scope of the license back can be a source of much discussion. The seller wants to maximize flexibility in the scope of the license back, while the buyer wants to restrict the scope so that it does not interfere with their patent rights. Where the seller is suspicious that the buyer may be overly zealous in enforcing the patents, the seller may wish to incorporate a covenant into the assignment contract that restricts the buyer from aggressive litigation and threatening licensing activity. This may become a topic of some negotiation. Recruitment and transfer of employees can become a discussion point, where the divestment involves more than a simple transfer of intellectual property from buyer to seller. In many situations, successful commercialization of the patents and technology is dependent on a specialist team of technologists. The transfer of product designs, software code, and other intellectual assets are important components in some transactions. Organizations are often looking to acquire patents and portfolios of strategic value. All types of technology and patents can be sourced through an outbound search. However, the sectors where this is most prevalent are those experiencing active patent litigation. Sellers are usually small patent holders and corporations that are pruning their portfolios and divesting of non-core assets. R&D labs are also sometimes open to the idea of selling patents. The buyers include patent pools, investors, and multinational corporations in fast-moving high-technology sectors. Depending on the nature of the assignment, the process of sourcing and acquiring new technologies, patents, and portfolios can take between 3 to 9 months. Some clients have ongoing sourcing needs, so the process continues for several years. Here are some of the steps involved. The process starts by gaining an understanding of your objectives, your customers, markets, channels, existing patents, products, and technology platforms. Then, the buyer or its agent conducts an outbound search. The buyer's requirements are analysed and custom online searches created for patent holders and organisations with matching assets for sale. Patent wanted listings are then syndicated to networks of brokers and intermediaries. Patent and technology wanted listings are syndicated through the online exchange and broker network. After reviewing the patents and portfolios matching the client's interest, a short list of candidates is prepared. The broker then approaches the patent holders and explores their interest in potential licensing or technology transfer. Deal points are negotiated. Hopefully, negotiations result in offers being accepted and deal terms being agreed by the parties. The patent purchase agreement papers are then prepared and exchanged. The buyer's lawyers conduct due diligence to ensure the seller has clean title and investigates patent validity. The legal documents and due diligence processes are completed by lawyers representing the buyer and the seller. The transaction is closed, and ownership of the patents and other assets is transferred. A license is a contractual agreement providing permission for the licensee to use and have access to certain property for a certain period of time. For patents and technology assets, there are a wide range of licensing structures and arrangements available, ranging from non-exclusive limited scope licenses to exclusive worldwide licenses with rights to enforce and litigate in court. Licensing transactions take place in all industries. However, the type of arrangements differ from sector to sector. License arrangements in the healthcare or medical sector are very different from those in the software industry. Semiconductor, OEM electronics components, communications and other high-tech sectors each have their own licensing conventions and peculiarities. Some patents and technologies form complete products in their own right and can be sold directly to the customer. But many new developments are in the form of components that must be combined with others in order to create marketable products. Generating revenues from components and platforms often requires OEM and other license arrangements in order to generate revenues. So licensing is a critical activity in some technology sectors. Corporate patent holders, universities and research labs often operate licensing units organized as offices of technology licensing, OTLs, or strategic licensing group, SLGs. These teams specialize in selling patents and technology licenses to large corporations, startups and other organizations with the sales, marketing and distribution channels that are necessary to bring new inventions and technologies to market. As corporations are often very secretive about their R&D activities, finding matching licensees for highly specialized technologies is sometimes likened to finding a needle in a haystack. The process takes time and effort, but can be very rewarding. Depending on the technology, the process can take 3 to 12 months from initial engagement to the closing of the transaction. Patent holders approaching potential licensees are often surprised to find their friendly discussions result in legal activities that are distinctly unfriendly. This is a result of the concern from licensees that the approach is a prelude to litigation for patent infringement. The way the potential licensee is approached is very significant. If a reasonable threat of infringement litigation can be perceived by the licensee, then the licensee has the right to preempt the case by bringing a lawsuit of its own. If the approach is made by an experienced intermediary, acting on behalf of the licensor, then the threat of litigation perceived by the licensee can be controlled and removed in most circumstances. The process of licensing involves forming an ongoing relationship between the licensor and the licensee. As the arrangement has to stand the test of time, it's important that a win-win structure is found and that each party feels positive about the outcome of the negotiation. A licensing agreement can be relatively complex, so the negotiation involves balancing a variety of objectives and concerns. Typical negotiating points include the size of the initial upfront license fees, ongoing royalties, duration of the license, termination and expiration terms, exclusivity, and field of use. A cross-license is an agreement between two corporate patent holders to pool or somehow share their patent portfolios. The objective is usually to prevent expensive infringement litigation between the parties and to defend against potential litigation from other patent holders. Cross-license agreements can take place in any sector, but most of the activity takes place in high-tech industries where patent litigation is a common and expensive irritation to large corporations. The parties to a cross-license agreement are usually large, multinational, high-tech corporations with common interests and overlapping patent portfolios. Often the cross-license will be part of a high-level strategic alliance. The two parties often share a common competitor or share an interest in advancing certain technology platform or set of industry standards. Following the initial introduction of the parties and the general commitment to collaborate and reduce the threat of litigation, these transactions can be remarkably simple to structure. A contractual agreement is drafted that provides each party with an assurance that it will not become the target of a patent infringement suit from the other party. Each company is provided with access to the other's patent portfolio for a range of purposes, usually including the right to assert the patents in defense of an infringement suit from another competitor. Antitrust concerns can become issues where the parties hold market power and the collaboration could be construed as restricting competition. Many corporate cross-licensees are also concerned about what happens to the agreement in the event of a merger or acquisition. When a cross-licensing partner is acquired by a competitor, what happens to the strategic alliance? If it terminates, what becomes of the confidential information that's been exchanged? These concerns are best addressed when the alliance is formed. When it comes to jointly pooling patents to defend against others, the parties have to negotiate the rights to join each other in lawsuits. Whether the joinder is voluntary or obligatory can be the source of some discussion. If one of the parties is acquired by a competitor, the collaborative nature of the relationship could be broken, so termination arrangements have to be carefully negotiated. A strategic alliance is a collaborative agreement between two companies designed to achieve some strategic goal. Strategic alliances include international licensing agreements, management contracts, and joint ventures. In the technology sector, strategic alliances usually involve a combination of cross-licensing and technology transfers, but they can involve joint development and joint marketing agreements under a complex arrangement. Strategic alliances are appealing to competitors in high-tech sectors, where a wide range of technical resources and abilities are required to bring advanced new products to market, especially where previously disparate industries are beginning to merge. An example is where the mobile telephone started to encroach into the video and entertainment business. Mobile telephone companies formed strategic alliances with media companies. These alliances will become increasingly common in all technology sectors, as corporations realize that pooling and collaboration arrangements can help them leverage shared marketing channels and R&D resources. The most successful relationships are formed when two large multinational corporations of comparable size and market power agree to collaborate and pool resources, and they seem to work well when they share a common competitor. Alliances can quickly fall apart when the two partners are of highly unequal power and size, as the imbalance can lead to conflict. Confidentiality is an issue when any corporation exposes its trade secrets and research and development resources to another. NDA agreements have to be carefully negotiated and carefully policed by the partners. The threat of future competition is another concern. As businesses alter direction and technology sectors merge, companies that were formerly collaborators can find themselves competing with each other. This can be a particular concern when one of the partners is acquired by a large corporate entity. Strategic alliance transactions often result from executive-level discussions and can be difficult for management and intermediaries to control, as they are often dependent on CEO involvement and sometimes require board-level approvals. The process of forming a strategic alliance has several phases. Firstly, there's the commitment to collaborate. These transactions only take place after each of the parties has made a commitment to collaboration. Where the corporate culture remains closed and sharing remains an alien concept, the partnering process cannot gather the requisite momentum. Then there's the matching process. The perfect match may be obvious in some situations, but often identification of potential partners can involve thorough analysis of the competitive landscape within an industry. Then there are the introductions and preliminary discussions. These can involve an initial meeting and high-level slideshows where each company presents itself to the other. Then there are confidentiality agreements. The parties negotiate NDA agreements before disclosing confidential information. Pilot projects may then be undertaken. A trial project is a good way of partners getting to know each other and establishing a working relationship. Then the strategic alliance commitment is agreed. This agreement can be very high level. Often it's merely an agreement to agree. Then specific agreements are negotiated. The legal teams on each side negotiate the terms of the various agreements that constitute the strategic alliance. Finally, a strategic alliance is not a discrete transaction. A multitude of activities continue to take place over time. In addition to transferring patent rights, as is the case with a pure patent sale, a technology transfer often involves transferring designs, prototypes, trade secrets, intellectual property, even technical staff. In its broadest sense, technology transfer means the transfer of ideas, information, methods, procedures, techniques, tools, or technology from the developers to marketing organizations with access to customers. Depending on the nature of the transaction, technology transfer deals can be structured in a number of ways. Sometimes a startup corporation is formed, and this becomes the container for the transferred assets. Sometimes the vehicle for commercialization is a division of an existing organization. The transaction can involve an outright sale of assets or a license with upfront fee and ongoing royalties. Technology transfers often take place in sectors where channels to market are highly specialized or very expensive to establish. Any type of complex technology can form the subject of a technology transfer. However, they're very common in the medical biotech sectors where drug and medical device developers transfer their technologies to large manufacturing organizations in order to gain access to established brands, retail, and specialist distribution channels, and other specialized routes to market. Corporations, government bodies, startup companies, and a wide range of organizations are involved in technology transfers. These transactions are most commonly associated with the Offices of Technology Licensing, OTLs, or Strategic Licensing Groups, SLGs, found within research laboratories, universities, and some high-tech corporations. The transferor is generally a research and development organization that does not have appropriate routes to market for the technology in question. The transferee is generally a corporation or startup with access to markets via sales, marketing and distribution channels that's looking to expand by sourcing new products and revenue streams. R&D laboratories and universities all over the world often receive government funding to support their activities, and government funding usually comes with strings attached. Technologies developed under these funding arrangements are frequently encumbered. Restrictions are placed on the sale and transfer of the resulting patents and intellectual property. Many government funding programs restrict the way resulting technologies are sold or licensed. Some restrict assets from being transferred to foreign entities. Others restrict outright sale but allow for licensing. As a result of these funding programs, many technology transferees are concerned about working within the guidelines, and the nature of the restrictions can drive the way the technology transfer transaction is structured. Technology transfers are sometimes the source of human resource concerns for both the transferor and the transferee, as some technologies are highly dependent on a core team of scientists, researchers and engineers. The transfer process involves individuals as well as assets. The terms of the transfer, recruitment, remuneration, and other human resource issues need to be carefully managed in these transactions. Confidentiality is a concern for many organizations involved in technology transfers, especially where patents and trade secrets are involved. As a result, confidentiality agreements are carefully negotiated by the parties and restrictions placed on how sensitive information can be used. If a license is involved with royalty payments determined by future sales revenues, the parties to a technology transfer transaction negotiate a variety of licensing issues. There's the scope of the license. Exclusivity, duration, enforcement rights and other points can be important. Then there's the initial license fee. The parties need to agree the amount of fee payable up front. Then ongoing royalty payments need to be agreed. The royalty calculation can be based on sales revenues, units, profits or other criteria. Reporting and audit rights are usually necessary to measure the sales or other figures in order to assess royalties. The licensor must be able to have access to this information from the licensee and to verify the accuracy of the reported numbers. Where the transfer involves the formation of a joint venture or startup company, these transactions can involve intense negotiation on a number of issues. The nature and the structure of the commercialization vehicle is one. In some cases, the technology is transferred into a new corporation or LLC. In others, it may be transferred into an existing corporate subsidiary or division. Joint ventures can be created, and the form of vehicle is a critical part of the negotiation. When a joint venture or new organization is formed, the ownership and structure of equity shares and the capitalization table can be the source of some discussion between the parties. The structure and makeup of the board of directors involves important issues of power and control. Appointment of the CEO and other officers making up the management team often involves some debate. In a technology transfer, the recruitment or transfer of the technical team can be critical to success. Many of these arrangements involve marketing support from either the transferor or the parent company to the transferee or both. The parties can negotiate advertising, promotional support, as well as distribution, sales, marketing, and business development. The process from initiation to final closing of a technology transfer transaction can take 9 months or longer, depending on the size and complexity of the transaction. The steps in the process include 1. The business plan. From the perspective of the transferor, the process starts with the identification of the technology to be transferred, estimation of the market opportunity and identification of the type of partner and business structure most suitable for successful commercialization of this particular technology. Planning is important, and the transfer process for most complex transactions starts with the preparation of what can best be described as a business plan, as it analyzes the entire opportunity, the strategy, as well as tactical implementation matters. Second step is the preparation of marketing materials. There's little point in approaching a potential transferee until the materials have a good description of the technology to be transferred and the resulting business opportunity. As these materials will be studied by both technologists and financial analysts, they need to justify the opportunity from both technical and financial perspectives. The next step is to create and circulate anonymous exchange listings. The listing summarizing the opportunity is syndicated to brokers and potential candidates worldwide via website, exchange, email, and other channels. The fourth step involves approaching transferee candidates directly. A list of potential partners is drawn up and targeted sales activities are directed towards these organizations, directly or where appropriate through their agents and intermediaries. The next stage involves presentations, demonstrations, questions and answers. When a candidate has been engaged and wishes to investigate the opportunity, technical specifications are exchanged, meetings are held, and the Q&A process can go on for several months. The next stage involves the negotiation of terms. In reality, the parties are negotiating from the moment they initiate discussions. However, the final terms are usually clarified and confirmed after the technical questions have been resolved. Then we move on to the term sheet. The general terms of the agreement are noted and exchanged and provide the lawyers with the framework from which they can prepare the final documents. This is followed by the due diligence process. Depending on the nature of the transaction, due diligence can involve analysis of the patents, the technology, the marketplace, validation of the entire business opportunity, and clarification of title to the assets to be transferred. Then the final closing. When the legal documents are agreed and the due diligence process completed to the satisfaction of both parties, the transaction can then close. The technology transfer then takes place. The transaction is completed and the process of commercializing the technology can now commence. In a distribution agreement, a developer agrees terms to sell its products through a distributor. A distributor is a middleman, wholesaler, agent, or company distributing goods to dealers, retailers, or customers. Distributors provide developers with rapid access to channels and markets. Even the largest corporations with the strongest sales channels appoint distributors to address foreign and other specialist markets. There's a major difference between US distributors and those in smaller markets. US distributors are often accustomed to merely shipping products for US manufacturers. The manufacturer builds the brand, creates market demand through advertising and promotion, and provides customer support in the United States. The main role for the US distributor in this model is to warehouse and ship products to retailers and customers. In overseas markets, where the developer has little or no presence, the distributor is often required to undertake local marketing, brand building, and customer support. In some cases, the overseas distributor is required to translate and localize the product. This creates co-ownership rights to the localized product that need to be carefully negotiated and defined. Local laws protect the local distributor in many countries, and international laws must be considered when drafting arrangements with overseas distributors. So, domestic distribution arrangements are often very different from international arrangements. Overseas distributors that are asked to invest in building a local brand, generating customer demand through marketing and supporting local customers, will need longer-term contracts, more sophisticated termination clauses, and more significant margins. Software, music, and digital media is increasingly being supplied online. These transactions involve bits and bytes being transferred over the internet, and there's no product shipped in boxes through the mail or retail stores. Digital distribution arrangements may be characterized as licenses, but the essential elements are the same as those covering the distribution of goods. The term OEM, standing for Original Equipment Manufacturer, generally applies to an arrangement where a product is designed by one party, but branded and marketed by another. Reflecting the specialization taking place in many industries today, and the significance of matching products with appropriate channels of distribution, OEM arrangements are increasingly popular today, and they come in a wide variety of forms. On one end of the scale, a technology developer can simply license the designs and intellectual property to a manufacturer, who then carries out all the product development, branding, marketing, and manufacturing. The developer designs products and components, but does not build or market them. The manufacturer builds and markets products designed by others. On the other end of the scale, OEM also refers to an arrangement where the developer undertakes the manufacturing of the product as well as its design. The product is then relabeled and marketed by another company using its own brand, sales, and marketing channels. In this scenario, OEM means relabeling and marketing products manufactured by others. Under an OEM model, the product could be designed entirely by one developer, but it could also comprise multiple components from a variety of designers. Clearly, there are a myriad of elements to an OEM deal. The contracts can become complex, and many points need to be carefully negotiated. However, these are essentially distribution arrangements with sophisticated branding, manufacturing, customer support, and intellectual property ownership provisions. A financing is an injection of funds into a business. For this presentation on technology transactions, we're focusing on investments involving collateral in the form of patents or other intellectual property assets. IP-backed financings can be structured as debt or equity instruments, so they can take the form of convertible notes or preferred stock issues. The investors involved in these patent-related financings are usually from high-technology sectors, where there's intense competition between multinational corporations and a good deal of patent litigation. These investors are often private equity groups or investment funds focused on building portfolios with strong intellectual property assets. The companies receiving these financings are usually mature startups or mid-sized corporations with strong portfolios. As with any investment, the investors are interested in the strength of the management team, financial performance in the past, the business plan and future projections. The status of the patent portfolio is often an issue for discussion. The nature and extent of licenses is of interest to the investors, so is the status of patent infringement. As a prerequisite to starting the process, the company seeking funding needs to prepare a business plan and catalogue its patents and intellectual property assets. These materials are then provided to investors for evaluation. Good company candidates are invited to make a presentation to the investors. Following this initial presentation and subsequent discussions, the parties negotiate the terms of the transaction. Like any financing, the whole process can take 6 to 12 months and can involve a good deal of business plan reformulation and discussion before a good match is found, with a suitable investor, and a financial transaction is then closed. As with any investment, the form of the instrument, debt or equity, is negotiated by the parties and their lawyers, together with the valuation, control in terms of board seats, and the rights provided to the investor. Bonds and debt-based instruments often involve covenants regarding liquidity ratios that the company is required to maintain. Equity instruments usually involve intense negotiation over the nature of the preferences provided to the investor with the preferred stock. Some investors are very interested in control and wish to negotiate seats on the board of directors. Other investors are more passive, have little interest in exerting any form of control over the operation of the company, and are more inclined to rely on management. These IP-backed financings also involve negotiation over the patent rights to be transferred to the investor. Liens can be placed on the patents, and the investor can acquire rights to enforce the patents against potential infringers.